Welcome to Easy Learning. Normally, the High Courts hear and decide the appeal filed by the convicted person and the reference sent by the trial court for confirmation of the death sentence together. Full stop. It has been noticed that while doing so, the learned judges of the high courts sometimes, as it appears to have done in the present case, remain content with examining and deciding only the arguments and contentions advanced in appeal, and do not by themselves scrutinize the whole material available on record of the case. Full stop. Even non-filing of appeal or withdrawal of appeal by the convicted person, or any concessional statement by the state council does not relieve the High Court from performing its duty of reappraising the whole evidence available on record. Full stop. Ordinarily, in a criminal appeal against conviction, the appellate court under section 423 of the CRPC can dismiss the appeal if the court is of the opinion that there is no sufficient ground for interference after examining all the grounds urged before it for challenging the correctness of the decision given by the trial court. Full stop. It is not necessary for the appellate court to examine the entire record for the purpose of arriving at an independent decision of its own whether the conviction of the appellant is fully justified. Full stop. The position is, however, different where the appeal is by an accused who is sentenced to death, so that the High Court dealing with the appeal has before it a reference for confirmation of the capital sentence under section 374 of the Code of Criminal Procedure. Full stop.